Hello guys and welcome to the Legist Law channel. In this particular session, I'll be taking you through how to tackle some core or fundamental aspects of constitutional law. Now, this particular session is very relevant to those who are having a review of constitutional law or those preparing to tackle any constitutional law paper. Now, the essential portion of this particular session will look at the supremacy of the Constitution, right, as well as the enforcement of the Constitution and also the jurisdiction of the court. So we have the supremacy, we have the enforcement of the Constitution, and then the jurisdiction of the court. Now, the applicable articles and the applicable cases will be those that have been decided in the particular country, Ghana. Now, what is supremacy? We all know that the Constitution is not an ordinary document. It reflects the will and ambitions of the people. Usually, the Constitution sets up the arms of government as well as their powers, their functions, and even the restrictions or the limitations on those particular powers. The Constitution also decides what is the relationship between the state and the people and how these arms of government should exercise their authority on the people. Now, supremacy. This means that the Constitution is supreme. Usually, it is referred to as the supreme law of the land or the basic law of the land. This means that any law that is inconsistent with the Constitution, to the extent of the inconsistency, will be declared null and void. So, under the 1992 Constitution of Ghana, we have this relevant article, Article 1 Clause 1, and also Article 1 Clause 2. So, Article 1 Clause 1 makes it essential or clear that the sovereignty of Ghana resides in the people of Ghana, and in whose name and for whose welfare the Constitution sets up the arms of government, that is the executive, the legislature, and the judiciary, with their powers and also the limitations on those particular powers. So you realize that this case establishes sovereignty of the people, and that sovereignty is vested in the Constitution. So because the authority of the state is vested in the people who intend to delegate that authority to the Constitution is above any law, any other law, even the law that sets up the arms of government or the extent of their powers. So it means that even if there is any act of parliament that decides to grant authority to any other body or institution, the Constitution as a law is still higher and is still enforceable over these particular laws. So then Article 1 Clause 2 is a very, very relevant provision. So it says that the Constitution is the supreme law of Ghana, and any law inconsistent with the Constitution will, to the extent of the inconsistency, be declared null and void. So then we are looking at enforcement. How are the provisions of the Constitution enforced? This brings us to Article 2 Clause 1 of the 1992 Constitution. Now, to enforce a constitution or to even enforce a law is to execute the law against acts or omissions or even any other law that is inconsistent with it. So there are three things that we can enforce the Constitution against: acts or omissions or laws. So any act or any omission or any law that is inconsistent with the Constitution will, to the extent of the inconsistency, be declared null and void. So Article 2, Clause 1 of the 1992 Constitution of Ghana is very, very relevant. This particular provision provides that any person who is interested in seeking a declaration from the Supreme Court can bring an action to the effect that a law or an act or omission is inconsistent with the Constitution. So the person seeks a declaration from the Supreme Court that a law or an act or an omission is inconsistent with the provisions of the Constitution. And so to the extent of the inconsistency, it will be declared null and void. So Article 2 Clause 1 is a very, very important provision. So in any question that deals with parties having a dispute over whether or not an act or law or omission is consistent with the Constitution, you need to first of all refer to Article 1 Clause 1 that establishes that the sovereignty of the state resides in the people. They need to establish that the people delegate their authority or their sovereignty to the Constitution, and the Constitution in turn sets up the arms of government as well as their powers and their functions and the limitations or the restrictions on their powers. So then, Article 1 Clause 2 makes it clear that the Constitution is the supreme law of the land, and any law that is inconsistent with the Constitution will, to the extent of the inconsistency, be declared null and void. So we then come on to Article 2 Clause 1, which also establishes that any person, right, any person can bring an action to the Supreme Court to enforce the constitutional provisions by seeking a declaration that an act, omission, or law is inconsistent with the provisions of the Constitution. Now, there has been some clarification on the meaning of the word any person. It has been established that there are two main actions that you can bring to enforce the Constitution. You can bring the action in the Supreme Court, or you can also bring the action in the High Court. Now, for the Supreme Court, the relevant provision in Ghana is Article 130, Clause 1 of the 1992 Constitution. And for the High Court, the relevant provision is Article 33, Clause 1 of the 1992 Constitution. And so the distinction is very important. Now, any person can bring an action to the Supreme Court under Article 2, Clause 1 and Article 130. So in this particular sense, it has been detected by several cases that the word any person in there means any citizen of Ghana, even including a dual citizen. So any person who can bring an action to the Supreme Court for a declaration that something is inconsistent with the Constitution is a citizen. So the person must be a citizen of Ghana. Right, it's very important to note. Now, it means that for the High Court, it deals with a specific genre or a specific aspect of breach. This is in reference to human rights infringement or human rights breaches. So if your human right has been breached and you are personally affected, then you can bring an action to the High Court. Usually, this will ensure that there is a speedy means of providing remedies to those who have their human rights impeached upon or infringed upon. So in this particular sense, the particular provision is Article 33, Clause 1. This means that where any person is personally aggrieved by an infringement of his or her rights or a potential infringement of his or her rights, that person can bring the action to the High Court. But if you are not personally aggrieved and you are bringing the action in the public interest to enforce the provisions of the Constitution, then you can bring it to the Supreme Court in there under Article 130. So the Supreme Court has interpretative and enforcement jurisdiction. So this means that any particular act or omission or even a law passed by Parliament that is inconsistent with the provisions of the Constitution will, to the extent of the inconsistency, be declared null and void by the Supreme Court. So it's very essential to note that for the interpretative jurisdiction, there are three types. So first of all, it has enforcement jurisdiction, and secondly, it has interpretative jurisdiction. This means a person might not necessarily bring an action to enforce the Constitution, but the person seeks an interpretation of a provision or another of the Constitution. So the interpretative jurisdiction of the Supreme Court also arises and Article 130 Clause 1 and also Article 130 Clause 2 of the 1992 Constitution. So Article 130 says that the Supreme Court has jurisdiction in the interpretation and enforcement of the Constitution. Usually it has original jurisdiction in the interpretation and enforcement of the Constitution. That is subject to the jurisdiction of the High Court in human rights matters. So you know the High Court is dealing with human rights matters. Okay, so now with the interpretative jurisdiction, there are three types as determined in the first case we are going to use, known as the case of ex parte accusa. Right, so that is the short form of the case. This particular case explained that there are three means by which a person can seek an interpretation of a provision of the Constitution. First of all, where the particular provision of the Constitution is unclear or ambiguous. This means that the provision is vague, and so you are bringing an action to the Supreme Court for interpretation of that particular provision. The second instance is where a provision of the Constitution is conflicting with another provision of the Constitution. So this means that there are two provisions in the Constitution and it seems as if they are in conflict or they are inconsistent with each other. This means that we need some sort of clarification from the court. The third means or the third way by which we seek interpretation is whereby the parties to the case have rival meanings to the same provision. That means that it is one provision, but the parties, that is the plaintiff and the defendant, have rival meanings to the same provision. That means that it is for the Supreme Court to interpret that provision to determine which meaning is correct or which particular interpretation is applicable. Now, we are going to have a look at a line of cases, right? A lot of cases that will portray the aspect of constitutional interpretation and enforcement. So I'll write the name of the case and I'll just give the principle in that particular case. So the first case in point is the case of Tufor versus the Attorney General. Now the facts are very simple, that basically there was a judge who was supposed to continue in office as dictated by the transitional provisions of the 1979 Constitution. What happened in this case was that it meant that the judge wasn't supposed to go through vetting and approval, since the Constitution already stated that he shall be deemed to have continued his office. Now, what happened was that Parliament still decided to conduct vetting and approval of the judge, and they actually disapproved him. So in that sense, the vetting process went against the judge. He wasn't approved. But then Tufor was not the judge. He was basically a Ghanaian citizen. So he brought the action to enforce the Constitution on the ground that since the Constitution is supreme, and since the Constitution says that whereby judges are supposed to continue in office, it means that they won't go through the vetting approval process or disapproval process, so the vetting process in general. It meant that the Parliament's action in vetting the particular Justice Apalu and disapproving him was actually inconsistent with the Constitution, and the court agreed. So the court held that any person means a citizen, because a citizen has the public interest in enforcing an action. So a citizen has the public interest, right, in enforcing the Constitution, right, in enforcing the Constitution to ensure that the Constitution is well defended from any breaches. So every citizen of Ghana has a local standard or an interest in the enforcement of the Constitution. And the court also held that the Constitution is the supreme law, so the action of Parliament was inconsistent with the Constitution and therefore declared null and void. The second case in point is the case of MPP versus the Attorney General. This particular case is referred to as the 31st December case. What simply happened was that there was a coup in the past on 31st December. Now, we are just giving the basic facts. So basically, there was a new Republican Constitution, that is the 1992 Constitution of Ghana. And the president at the time, President Rawlings, declared that 31st December will be celebrated as a public holiday to remember the coup. Now, under Article 3, Clause 4 of the Constitution of Ghana, that's the 1992 Constitution, every citizen has a duty at all times or a responsibility to defend the Constitution, especially defending it against treason or doing anything in our power to restore the Constitution back if there is treason. So then it meant that the celebration of a coup d'etat with public funds is inconsistent with the spirit of Article 3, Clause 4, and the court agreed. Therefore, the court declared that since the Constitution is supreme over any action of the president, over any law that is being passed, the celebration of a coup, which is inconsistent with the Constitution, will not be allowed to be done with public funds. Therefore, the court held that the Constitution is supreme, and once it is inconsistent with the Constitution, the court can prohibit the particular action from being done. The third case in point is another case with the MPP, that is MPP versus IGP. Now you realize that there are two cases with NPP in the list of examples I've given, but these particular parties, right, that is the MPP, right, it is a political party, it isn't a natural person. So it means that an artificial person can still bring an action to enforce the Constitution. But this artificial person must also be a citizen of Ghana. And how is that so? The artificial person or the artificial body must be incorporated within Ghana, right? And that will make it a citizen of Ghana. So in the case of NPP versus IGP, under Article 21 of the 1992 Constitution, right, our freedom to go on protest or our freedom of assembly is actually guaranteed under the Constitution. Now, in a previous law known as the Public Order Act, a particular provision provided that any person or group of persons who was going on a protest must inform the IGP and get the license from the IGP or the authority from the IGP before the person can go on the protest. This means that the IGP can reject the person's application to go on a protest. Now, of course, NPP brought an action claiming that now the IGP doesn't have the authority to prevent us from going on a protest, and we don't need to apply for a particular license from the IGP before we can go on the particular protest. This is because of the fact that our freedom of assembly and our right to partake in demonstrations and protests is actually guaranteed under Article 21 of the Constitution, and the court actually agreed. So the court was of the view that whereby Article 21 has made a statement that guarantees our right to protest and our freedom of assembly, the previous law, that is the Public Order Act, the provision within cannot restrict our right to assembly or our freedom to protest unless, of course, it is in the public interest. This means that to enforce and protect the public interest, any person who is interested in going on a protest must simply inform the police of the particular route that the person intends to take and the particular date of the protest. Now, if the police do not agree or they have an issue against it, they can simply go to the High Court for an application or injunction to simply stop or to prevent the particular person or body from going on the protest. That was the decision in NPP versus IGP. Now, this means that a particular law can be totally struck out as inconsistent with the provisions of the Constitution. This brings us to the case of Professor APIJ Etua. So the spelling is in there on the board. Professor APIJ Etua versus the Attorney General. So what basically happened was that this particular case is a very interesting one. During COVID, the Parliament of the state decided to pass what is known as the Imposition of Restrictions Act. This grants the president authority to declare certain places under lockdown. Now, obviously, we have the freedom of liberty and the right to go wherever we want to. So the freedom of movement too, under Article 21 of the Constitution. And usually, such massive curtailment of our freedom cannot be done unless it is under a state of emergency. So Professor APIJ Etua brought an action to the Supreme Court that the entire law is inconsistent with the Constitution because it grants the president wide arbitrary power to impose lockdown or restrictions on our movement. And this is actually inconsistent with Articles 21 and Articles 31 and 32, as well as Article 14 of the 1992 Constitution. And the court actually agreed and held that the particular law is inconsistent with the provisions in the Constitution. Now, another relevant case we can also have a look at is the fifth case. This is basically known as the case of Ezuami versus the Attorney General. Right, the fifth case, the case of Ezuami versus the Attorney General. So in this particular case, what basically happened was that there was the passage of a particular law, and this law had a provision that wasn't in there at first. But when Parliament was reviewing the law, Parliament decided to include that provision in the law. Now, under Article 106 of the 1992 Constitution, it is expressly provided that in order to pass a bill, that particular bill must be presented before Parliament with an explanatory memorandum that explains every provision in the bill. This basically meant that if Parliament included a new provision in the particular bill, then Parliament had to attach an explanatory memorandum. So they didn't attach the explanatory memorandum, and of course, Ezuami brought the action to enforce Article 106 of the Constitution. And the court agreed that that particular provision should be struck out as null and void because it is inconsistent with the provisions of the Constitution. So this is the extent of constitutional supremacy. Right? The Constitution is the supreme law, and any law that is inconsistent with the provisions of the Constitution will be declared null and void to the extent of the inconsistency. This means that power is vested in the court to exercise what is known as judicial review, to review the actions of the executive and the legislature, and also the laws that are passed under the authority of the legislature, to determine whether or not all these actions are inconsistent or are consistent with the provisions of the Constitution. This is the basic tenet of constitutional law, and there are so many other cases on this particular principle. So we can even have the case of basically Professor Asare versus the Attorney General, or another case of NPP and Attorney General known as the Siba case, or another case known as Mensima versus the Attorney General, or another case known as J.H. Mensah versus the Attorney General. There are so many constitutional law cases that reflect the same principle, that the Constitution is supreme, and any law that is inconsistent with the Constitution will be declared null and void. So in order to learn more about constitutional supremacy and the enforcement or the interpretation of the Constitution, you should pay regards to the Legis Law Club by visiting their website in the description below, as well as looking for other videos that are attached to this particular segment. Now, these videos will move on to explain other topics such as constitutionalism, right, separation of powers, rule of law, coup d'etats and revolutions of the Constitution, the executive, the legislature, the judiciary, and many more. Till next time, thank you so much for joining. I'd like you to also share, like, and subscribe. Bye bye.